First order of business is to extend a very warm welcome to our newest board member, David Little. I think in the history of the ZBA, no new member has joined this board with more experience and knowledge of the bylaw than Mr. Little. So it's delightful to have you join us, David. Welcome.
Thank you, you're very kind.
No, not at all. I'm just being factual. Now, the other thing I'd like to do tonight before we, well, let me call the old business first. We have to review the minutes of the meeting of March 19th, 2025. Is there any questions or comments on those minutes? I may need to add a little section about the motion. Jen said she wasn't certain she had that right. I'll review that after this meeting, and if you would allow me to make that necessary change, I'd appreciate a motion to approve the minutes.
Yeah, I move to approve the minutes with that clarification that you'll make.
Thank you. Is there a second?
I'll second.
Oh, thank you for that. All in favor?
Aye.
Any opposed? Great, that passes. Before I call the first case for consideration, our only case tonight, I'd like to review the process of how we need to go this evening. First and foremost, we should consider this as a new case, a clean slate, tabula rasa, if you will, and we are to consider the case on the basis of the submission, the written submission by the applicant, and any testimony this evening. That would be the basis. Any experience we've had in the past should be forgotten, and we look forward to this discussion based on the evidence before us tonight. I don't see that Mr. Silverstein has joined us. He's going to be joining us electronically, and he explained to Mike Ford that he's going to be only a voice for the first part of the meeting, and eventually we'll get to see him on video. There he is now. Mr. Silverstein. Great.
Good evening, Mr. Chair.
Good evening, Mr. Silverstein. We have you in video too. Terrific.
You do.
I was in the process of explaining that we are going to consider this application tonight solely on the basis of the record that you have submitted, the application you've submitted, and the testimony presented tonight. Any considerations and deliberations we had previously are to be forgotten, and we start as a clean slate.
I did hear that. Thank you. I appreciate that.
Good. Now, the way I'd like to proceed...
Mr. Chairman, Mike Ford, can I just add one thing to that?
Please, Councilor.
You're correct that your prior decision was annulled by the judge in the land court, so you are starting fresh. That said, the submittal by Mr. Silverstein was a supplemental submittal, as I understood it. And so the original applications that were filed are still part of the record, those applications. All right?
Yeah,
You need to hear it fresh, but, and Mr. Silverstein, if you disagree with that, let me know, but I believe that's the way your submittal was done.
Yes, that's absolutely correct.
Okay.
Very good. I stand correct. Thank you, Michael. So the process I'd like to, once I call the case, I'd like to call upon Davis Walters to give us the background of the order. And then we're going to talk to question him and any issues we have with his order, and then call on Mr. Silverstein to reply. So with that, I'd like to call the case number 2025-05 for the order of remand issued by the land court for Perseverance Coast LLC. Mr. Walters, please.
Mr. Chairman, thank you.
Mr. Chairman, are you going to
Yes.
assign members to this case?
Well, we only have 5, and they're all going to be voting, Mr. Ford. I will assign them
Okay,
all.
fine.
We
All
have
right.
5, we have a full, I should have said, we have a full cohort of 5 members. David Little is an associate member, but he'll be voting tonight as a regular member of the board.
Okay, all right. Thank you.
Davis, please.
Thank you, Mr. Chair. So I have an extensive history of the events up to today, but I'll begin, if it's all right, with just the events of last April, just what prompted the initial zoning enforcement. So on April 1st, I got a complaint from a tenant at 260 Route 6A saying that there was construction noise coming from the upper floor of the building. There were contractors coming and going, dumpster in the parking lot, and storage containers having been recently delivered to the parking lot. On the 9th of April, I went to the site. The building was open. There were workers inside. I went inside and observed that the third floor interior partitions had been, for the most part, removed. There were 2 workers inside who identified themselves as electricians' helpers who were stripping wiring as part of the demolition process. No building permit application had been received for that work up to that time. So on the 18th of April, as a result of that site visit, I sent a zoning enforcement letter by certified mail to the building owner regarding the unauthorized work in the building, as well as the presence of the 21 storage trailers which have been placed in the parking lot on the property. So that's the beginning of the story. What else can I tell you?
Any questions from the board members?
Did that original zoning enforcement or note the 5 separate items, or is that solely for the use or the storage containers on the property?
Yes,
There's
thank
also
you.
parking and signage
Thank you,
related
Austin.
items.
The zoning portion of the letter explained that the trailers were prohibited in the district. I also indicated that no zoning permit application had been submitted for the changes to the business sign out front. Those are the 2 items with regard to zoning that were contained in my letter. I also indicated to the owner that because he was in the district, that he needed to seek approval for the changes to the property by Old Kings Highway.
There was let me ask you this, maybe we'll get into this. There was also an issue with the Conservation Commission had an issue. I don't know if that has been resolved. Has that been resolved?
Mr. Chairman?
David, do you have a question?
Yeah, so I stopped by the Conservation Commission office today, and with that question in mind, and they gave me a copy of an order of conditions that was issued to the applicant, and a copy of the approved site plan that was in their file, which I have with me now. And the Conservation Commission did approve the project with 3 special conditions,
Okay.
which I'd be happy to share if you'd like.
I don't think it's necessarily relevant for us, as long as we know they've been through the Conservation Commission, and unless you think any of them relate to zoning, I don't think it's any.
No, I don't think it really has any bearing on what we're going to be doing this evening.
Very good, thank you very much, that's great. All right, Mr. Silverstein, would you like to respond to, well, I guess, are there any other questions of the building commissioner from the board?
Jerry, could I
Yes.
ask a question? Mr. Walters, is the Old Kings Highway or the Architecture Committee something that the applicant should be going through also, besides us?
In this case, because of the location of the property, the Old Kings Highway Historic District Committee has jurisdiction over any and all changes to the exterior of the buildings, signs, or additions to the property. The Architecture Review Committee, because of the Old Kings Highway, does not have jurisdiction. So to that end, we asked the applicant, I believe it was sometime later that spring, was asked to apply to Old Kings Highway for permission for those storage containers to be there. The case was heard, the application was denied, and I did reach out to counsel for the Old Kings Highway Regional District Commission and asked him if he had received an appeal from the applicant as a result of the denial by the local committee, and he said no. That was long after the appeal period had passed. And to my knowledge, that's all that's been done to this point with regard to Old Kings Highway approval.
So what does that mean to us?
Well, I mean, it's outside the purview of zoning specifically, and to my knowledge, the applicant is allowed to reapply to the Old Kings Highway District Committee, that is the local committee, as many times as he chooses, whether there are any significant changes to his application or not. That's the way the laws are written with regard to the Historic District Act.
So we can overrule the Old Kings Highway?
No. The Old Kings Highway, the authority of the Old Kings Highway Committee is distinct, and it is not, it's not influenceable by zoning or any other board. It stands-
Mike, did you want to address this, please?
Yeah, Davis is correct, Mr. Chairman. The Old Kings Highway, while it might be information that can be imparted to you tonight, it's not before you. That's a separate board with separate jurisdiction, and Davis is correct. They have to satisfy whether they need a permit from the Old Kings Highway, and if they do, they have to obtain that permit. But that's not before you tonight as part of this hearing.
Okay.
This
All right.
first part of the hearing tonight is really an appeal of the building commissioner's April 18th, 2024 order that had 5 things in it as to what was in violation of zoning. I'm not sure he's gone through that as yet, but that's really what this first part of the hearing is.
All right, thank you, Attorney Ford.
It might be a consideration if we get beyond this and consider a special permit request or a variance, because we have a tradition. It's not, I don't think, codified. We have a tradition of being lost in line. I would suggest if we get there, that we talk about whether that's makes any sense to adhere to that tradition at that time. So we'll put that off until we see if we get to the special permit portion of the hearing.
Mr. Chair?
Yes.
Just for that sake, I will say, just for informational purposes only, that in my mind, there are 3 fronts here. The one at hand is the zoning violations. Another is Old Kings Highway approval, and the third one is building code. So I just wanted to let everybody know that broadly, those are the 3 general items of enforcement under consideration here, although tonight obviously is about zoning.
And we had some time constraints upon us based on the discussions with the court. Isn't that right, Mr. Ford?
That's correct.
Yeah. So I think we should proceed and resolve as much of this as we can tonight.
Jerry,
I think
quickly,
we should, our goal should be to, I think our goal should be not to put this off for other boards to consider, but to come to some conclusion on behalf of the zoning issues.
Jerry, one quick note. Could you clarify the timeline requirements here, just for my information?
Well, I'll ask Mr. Ford to do that.
Mr. Ford?
The latest remand, if I've got it here, order. Requires the applicant to have submitted their materials to your board by March 14th, which they did, I believe on that date, and for the board to open, hold, and conclude the remand hearing by June 14th.
Okay.
So you have some time. It's not as if you're up against it, but you do have to conclude the remand hearing by that date, then file your decision within 20 days after that. Within 5 days of your filing the decision with the town clerk, I have to notify the court as to what that outcome was with a copy of that decision.
Thank you, Mr. Ford.
Other questions of the board for Mr. Walters?
Yes, Jerry David Little.
Yes, Dave.
May we request that the applicant's representative, since his application brings up 1, 2, 3 items, 1, the appeal of the building commissioner's zoning enforcement order, 2, alternatively a special permit, and 3, alternatively a variance, that we listen to those in that order and deal with each one separately to keep things moving in an orderly manner?
Well, that is my intention, Dave, and I'm sorry if I didn't make that clear at the very beginning. The order we're proceeding is we will consider his request, so we overturn the order of the building commissioner, and depending on what we do there, if it's required that we go on further, we will then consider an application for a special permit. And if the special permit isn't granted, then we'll go on to a hearing to see if a variance would be allowed.
Thank
So
you.
that is the intention of how we'll proceed tonight. Thank you. Mr. Silverstein, would you like to respond? Would you like to make a presentation to overturn the building commissioner's order?
Thank you, Mr. Chair, I would. I want to start off by acknowledging that, as you said, this is a clean slate, and I appreciate that, and the board's time hearing the matter on remand tonight. I do want to acknowledge that I recognize that there's a history underlying this matter, and my hope and my client's hope is that that can be history, that we can move on and hopefully find a good resolution that protects the town's concerns, satisfies zoning, and allows my client to make some beneficial use of this property, which is largely vacant at this time, has been for most of the time that my client has owned it, and obviously is resulting in a great deal of financial hardship to my client. So I don't say that in any way to ask for special consideration or treatment, really just by way of hoping that this can be the beginning of a new path forward, and that we can reach some resolution. So I guess before I get to the zoning issues, Mr. Chair, I didn't know if you or the board wanted me to briefly address any of the other issues that were brought up, Old Kings Highway, building code. I'm happy to, but I also don't want to go down a path if the board isn't interested in hearing it.
I think those are extraneous matters, and we should let each body take those under their own control, not ours.
Fair enough. As has been explained, the first part of the submission before the board tonight is an appeal of a zoning enforcement order by Mr. Walters, and that zoning enforcement order identified 5 different potential violations. Not all of them are zoning. I'd say the first 4 of them are zoning, but I'll list them and then I'll address them each separately. So the first, I think, is really what the crux of the issue is, which is whether the property can be used for storage purposes. And the zoning enforcement order indicates that that is not an allowed use. The second is that a change of use greater than 1,000 square feet requires site plan review. The third is that the removal of parking spots, referring to the placement of storage containers in a portion of the back area of the parking lot, may violate parking requirements. The fourth is that the location of storage units appears to violate setback and screening requirements. And then the fifth, as has been referenced, is that a new business sign required approval from the building commissioner and the architectural review committee. So I think as we've discussed, that last item on the list really isn't a zoning consideration, and so unless the board wants me to, I don't plan on addressing that in great detail. With your approval, I'd like to briefly address items 2 through 4 before I come back to item 1, which is what I'll call the main event, the storage issue.
Very good.
So the second item addressed by Mr. Walters in his zoning enforcement order is that a change of use greater than 1,000 square feet would require site plan review committee approval. So though I question whether there has been a change of use that would trigger site plan review, as I noted a few times in my submission, the applicant would be willing to proceed through site plan review as a condition of any approval by this board, whether it's upholding its appeal, granting a special permit, or granting a variance. My client is prepared to proceed through site plan review as a way to address any concerns that there might be in terms of the way that the site is or is proposed to be used. So I don't want to dwell on whether or not site plan review is a requirement, because my client is prepared to go through that process.
Well, we may have to come back to that, Mr. Silverstein, depending on where we end up in this process. Because if we get to the special permit or the variance, it's an issue we'll have to decide how to proceed.
Understood. So the next issue raised in the zoning enforcement order is compliance with parking requirements. So the office use under section 34 of the bylaw, the office use would require 43 parking spaces. Currently, even with the storage containers in the back parking area, there are 46 parking spaces, which would comply with full use of the building as an office. I will note, again, there is no office use currently other than perhaps the my client's own administration of its office, but that's a very minimal portion of the building, and so there isn't full utilization of the building for office, but even if there were, we would have more than the required number of parking spaces. In terms of storage is actually under the bylaw, although storage is not listed in the table of uses, it is listed in the table of parking requirements as a use, and the requirement for storage is actually 1/10 of the requirement for office use. So clearly, the much more intensive use in terms of parking demand and traffic is an office use, and we satisfy even that more intensive requirement. The fourth item listed on the enforcement order was that the storage units appear to violate setback and screening requirements in section 164.27. So I'll address that in two ways. First of all, we think that the storage units are adequately screened, but I'll reiterate that if additional screening were required or requested during the site plan review process, that we'll voluntarily proceed to, then we'd be happy to install reasonable additional screening. I would note that the abutting land uses are significantly more intensive and unsightly than any use on this site, but that's neither here nor there. We're happy to install any applicable screening. We more than comply with any required setbacks. And I guess lastly, I will note that 16427 refers to trailers. I don't think we need to get bogged down in the question of whether these are trailers or not, because I don't think they are for the reasons I outlined in my letter, but we comply with all of the required setbacks in any case. And so I don't think there is, and I appreciate that at the time Mr. Walters issued this letter, you know, he probably had an opportunity to measure the distance to the property line, so and he was careful to say that there may be a setback violation, but there is not a setback violation, even if Section 27 were deemed to apply. So I will quickly just address the, to the extent that, oh, I'm sorry, did someone have a question, Mr. Kip?
No, I don't think so.
I will quickly address the last item of signage, because although there have been suggestions that the change of signage might trigger some other type of requirement, to the extent that the enforcement order is intended to cite a violation of Section 35 of the zoning bylaw, which requires approval of a quote-unquote new sign. As indicated in my letter, there is no new sign. All there is a switch out of the placard, but you know, that's just the content of the sign, and of course, as the board is well aware, content of a sign cannot be regulated by zoning. The structure of the sign, the dimensions of the sign, the location of the sign, the sign itself is the exact same sign that's been there. The only thing that was switched out, and if you look at the side-by-side photographs I included in my submission, you'll see that the signage is, if anything, less than what was there previously. And I don't think that just changing the wording on a sign without changing the dimensions or structure of the sign constitutionally could trigger any sort of zoning requirement. To the extent it does, I think that if there's some sort of administrative process we need to go through to register a new sign or something, we can certainly do that, but we haven't erected a new structure, a new sign of any kind. So I'll pause there for a moment, see if members of the board have any questions, and then I'll go back and address the main issue.
Are there any questions about those three issues? Or four issues, if you want to include signs. Any questions from the board?
I have a couple. I'm going to address them in reverse order, just because it's fresh in my mind. Talking about the signs, you know, the specific item that Davis had noted, 16435C for sign permits. That C1 says no sign shall be erected or altered without a permit granted by the building commissioner. And as a part of that, applications for sign permits include sketch or photograph of proposed sign showing size, colors, and materials. Davis, when we talk about signs being erected or altered traditionally, are we talking, I'm only commenting because color is noted, which to me generally refers to the color of the signage itself. is that something that we've traditionally required permits for, is the changing of words and pictures on a sign despite no other changes? I think back to other cases we've talked about, I believe Concord Electric Company or Concord Electric on West Road, we had gone through that process and they had retained the same sign, but they had, had a separate logo that they were going through.
Yes, Austin, the key word there is alter or alteration. So traditionally, to your question, in every case, a zoning registration or zoning permit for such a change to a sign, an existing business sign, has been required by this office for as long as I've been working here. So that is the nature of my identification in the enforcement letter, that any alteration to a sign according to the bylaw needs to be approved by this office.
Thank you. And I think looking at the comparison before and after, I mean, it's a fairly minimal change, but I think from a process perspective, I tend to agree with the order. I don't think it will be a problem from my current position. Sorry, I'm pulling up my list of items. The parking spaces, like you had noted, the parking requirements for warehouse or storage facilities is less restrictive from a numbers perspective compared to what an office would have. Because this use is not in the traditional footprint of a building, if we were to, say, consider the footprint of the storage units themselves, though not a building by our classical definition, would you estimate that we would still be within that requirement? I don't need any hard number or anything, but there does seem to be a significant amount of parking, but I figured I would clarify that it's not a storage facility in our traditional sense that it is fully enclosed in a building, but it is still taking up space on the property.
Through you, Mr. Chair, yes, because we're, I think, 3 or 4 spaces over the limit, again, assuming that the building is fully utilized for office space, which it's not, but we would still be 3 or 4 parking spaces over the requirement for the building, and the required parking for storage, I believe, is 1 space per.
I have it as 3,000 square feet.
3,000, so, I mean, even if we had I don't think we have 3,000 square feet if you total up all of the storage units, but it's certainly not 9,000 square feet.
All right. Perfect, thank you. I'll reserve my questions for number 2, talking about the site plan review for after we've discussed 1. And then, yeah, I think that concludes my items for 2 through 5. Thank you.
So we have a problem with semantics. We refer to these as storage units, which lends itself to want to believe that it's a building when in fact they're storage trailers. And the way that they get dealt with is specific to item number 1 of these 5 things. And with respect to items 2 through 5, I don't feel the need to get into that right now. I do feel that the crux of the issue here is number 1, storage for storage trailers. I think the applicant wants them to be considered storage units. If you Google a storage unit, you see a building with bays in it. If you Google storage trailers, you see exactly what's been placed on the parking lot in this site. So my concern is specific to number 1, and I I stand by the building inspector's,
Okay,
Opinion.
David, let's hold that. Let me ask Mr. Silverstein, he hasn't made that presentation on the use yet. He's held off on that. And I think that question will go specifically to the first question, the first item that you suggested. And let's hear Mr. Silverstein's case before we question him on it, all right? Mr. Silverstein.
I thought that he noted it earlier, but no, that's fine.
Yeah, good, thank you.
Thank you, Mr. Chair. So I guess just really quickly, to address a couple of the issues that have been brought up. In terms of the signage, I guess I will note, if you look at the side-by-side, there's a first floor space for rent sign, I believe. That was before the prior tenant moved in and put up a sign. I'll note that Mr. Ford obtained all building department records relative to this property, and there were no records of any permits approving any sign changes for putting up the office space for rent or the sign of the prior tenant or any other placards for any of the tenants that have been in and out of this. I think at one point in the side-by-side, October 19, it was Coastal Engineering. I think that changed to Ty and Bond. And I'm not aware, I haven't been provided copies of any sign permits for changing out those placards. So, I agree that this really isn't a major obstacle, because if it's just a matter of coming in and paying a fee and getting an approval for, the new placard, we're happy to do that, but I did want to just make that quick point. In terms of Mr. Little's point about the storage use, I haven't addressed the storage use. I have addressed the suggestion that these are trailers. I cited to federal regulations. These are not trailers. If at the end of the day, it makes a big difference, and I don't want to go down the rabbit hole, but I will note that there are storage containers all over town that have never been treated as trailers, to my knowledge. But if it makes a difference to put up a shell building around these storage units, corrugated metal or something, I think it wouldn't look particularly good, but it would end up not really changing anything. But if that makes a difference in terms of the board's ultimate determination, we could look into doing that. We satisfy setbacks if we did that, but it doesn't seem to accomplish a whole lot. But I think from a definitional standpoint, these aren't trailers. I don't believe they've been treated historically as trailers. They're not vehicles, which is the definition in the bylaw. So I just wanted to make that point.
Mr. Silverstein, you did cite the CFR. I don't think you have to get there, because I think our definition covers this issue. The definition is pretty simple. Any vehicle or object. If you are object, clearly they're objects, which is or has been or may be portable. They're obviously portable. They're used as portable storage containers all over the world. It clearly, in our code, in our bylaw, they clearly, in my mind, fall within the definition of a storage tree. The word "or object," it gives a wide latitude to what could be there in considered trailer.
And in the schedule of use, it's a storage trailer, not a trailer, a storage trailer. And by definition, a trailer is portable, and those units are portable.
Yeah, well,
They
it's
got
also-
their,
Yeah,
I would note that
The code requires it to be a vehicle, the CFR, but our bylaw does not. think you don't go to the code if the answer is in the bylaw itself. But anyway,
So I take your point, Mr. Chair, I think sheds are portable. You can take a prefab shed and put it on a slab, just the way you can take these storage containers and put them down in the parking lot. I do think it's relevant to look at how the bylaw has historically been applied. And there are, as I said, storage units like this all over town that have never been treated as trailers. In terms of the schedule of uses, it's only referenced in the accessory use definition.
well, there's a chart.
I'm sorry, the table, the accessory use
Yeah.
table.
Right, well, it's also in the main table. It does wholesale and storage, it gives two examples, but it doesn't specifically state, go into definition, but interestingly, both those examples precluded from the general business district.
Well,
So,
yeah, so I mean, that's gonna bring us into my next point.
right,
I will note that Mr. Walters' order did not cite a violation of the being quote-unquote trailers that are prohibited in the general business district. He had two separate items. One, storage is not allowed, and two, setback and screening requirements, citing to the trailers section. So, I think if we're looking at an order issued that identified specific potential violations. One was a potential violation of screening requirements applicable to trailers, and another is the use. But the use enforcement order was not, these are trailers that are prohibited. So I think we're going outside the scope of what the zoning enforcement officer listed as violations. But all of that being said, again, if somehow it makes a difference to the board for these units to be enclosed in a corrugated aluminum structure or some other structure so that, they're contained inside rather than what's there now, that could be arranged. It doesn't seem to accomplish much or really further any zoning purpose. And it doesn't, as I said, seem to be consistent with how the bylaw has been applied previously, but I don't want to get hung up on that issue because I don't think that we need to. And I'm trying not to get hung up or argumentative over something that I think we can move past.
I agree with you, Mr. Solis, and I don't think those issues are appropriate for this consideration of the building commissioner's order. I think what's only important to be considered is whether the building commissioner was correct in his order, and whether he followed the bylaw. And, when you get into trying to make it, you're gonna put corrugated things around it, that would be inappropriate for a special permit or variance discussion. I think the issue before us tonight is, was the building commissioner in error in his order?
So, and I agree with you, Mr. Chair, and I'll move on. So, his order, in terms of the trailer provisions of the bylaw, his order only identified setback and screening requirements. As I've said, I think we satisfy those requirements and, to the extent we need.
The main point of his order was that it's not a permitted use. The others are, I consider, you can identify them as sort of ancillary. The basic thrust of the order was, this is not a permitted use in a business district.
Storage is not a permitted use.
Right.
And
Yes.
yeah, and I haven't gotten to that point yet. he didn't cite to the accessory use table that talks about trailers. And that's my only point. Absolutely, you know, the main issue here is whether the use is allowed or whether it's not allowed. I don't want to dwell anymore on, as you said, issues that I think are ancillary and can be addressed.
Let me call on Austin, you have a hand raised?
Yeah, just kind of reiterating what I just heard. If we could focus solely on the words that are in the order one bullet, storage is a prohibited use in the general business district. There are currently 21 storage containers located in the rear parking lot. Application to the zoning board of appeals for a variance is required. So that alone, storage is a prohibited use in the general business district is the finding of the zoning enforcement officer. I'd like to focus our discussion on that one sentence and the accuracy and validity of that sentence if we could, and shelve all discussion about trailers until we get to a point in which that becomes the only path of discussion.
I agree, I think that's a
Makes
good
sense.
idea.
Yep. I take the point. I'll move on to that issue. So,
Thank you.
you know, Orleans is not alone among communities that over time perhaps ambiguities have arisen in their zoning bylaws. It's interesting because, as you pointed out, Mr. Chair, in the table of permitted uses, there is a heading that says wholesale and storage, and it lists two uses. One is sale of fishing bait, fish and shellfish, which really isn't storage and isn't wholesale. And then the only other one is a wholesale business that involves storage and distribution of goods. You know, your traditional definition of a wholesale business. Neither of those is actually storage. In contrast, there's a separate provision for the storage of boats, for contractor yards, which involve storage of equipment, for a number of other types of uses that can involve storage, and that I submit are actually closer to the type of storage use that my client is hoping to make of this property than a wholesale business. And so you could you could say, well, so there's actually no quote-unquote storage use listed anywhere in the use table, therefore it's a prohibited use. Because any use that's not specifically allowed is deemed to be prohibited. But that doesn't gel with the fact that storage is specifically identified as an allowed use, or as a use for purposes of determining parking requirements. And so the point I make in my submission is that, as with other uses that have been allowed in the town, even though they're not specifically listed and arguably don't specifically fit within one category or another, that a storage use is similar to a lot of these other types of uses that can be permitted in the general business district, such as a contractor's yard, such as light industrial, which is an undefined term and can easily be viewed as something broad enough to include the types of businesses that are taking place on properties abutting this property, that have been taking place, and expanding and changing over time, including with storage containers, including storage of equipment and materials. And that the fact that those sorts of uses have been allowed over time at many other properties in town, though not precedential, should help to inform a reasonable common sense reading of the bylaw that a use like this, that's substantially less impactful than other uses that are specifically listed, that has been allowed to happen in other locations throughout the town, should be deemed to be a use that may be permitted as within the general penumbra of, say, a light industrial use, a contractor's yard. I think it's a common sense reading of the bylaw. It's a reading of the bylaw that's consistent with past practice, and that is essentially the basis for my request that the board not deem this to be a prohibited use that requires a variance.
Thank you, Mr. Silverstein. Questions from the board?
Yes, Mr. Chairman. So I understand where you're coming from, Mr. Silverstein, when you refer to a contractor that might have a trailer in his yard for his own use, or someone who might put a trailer in their yard for temporary storage for a period of time. But the applicant here isn't putting these storage trailers in the back for his own personal use. He's putting the storage trailers in this property in the general business zone to lease them out to people. It's a completely different application. It's apples and oranges as far as I'm concerned.
I'm not saying it's a contractor's yard. What I'm saying is that
No, but this isn't for the use of the applicant. This is for the applicant to rent to individuals to come and rent out storage containers. That's not what's happening in all of the other instances that you were referring to.
Yeah, if I may add to that too, I totally agree with that. It's not an ancillary use to some other use. He's basically, this is his business to rent them out, so it's different totally.
I understand that, and I'm not saying it's identical, just like a TV repair person isn't identical to, I forget what is specifically listed in the table of uses, small appliance repair. I think my point is the purpose of zoning is to ensure that classes of land uses that are perhaps more impactful aren't placed in close proximity to more sensitive land uses, and that property is used in a way that is beneficial but not overly impactful. And my point is that the use that we're proposing, a light industrial is a very broad category, and it's undefined in the bylaw. And I certainly think that the board could make a determination that that broad category could include something like storage use as proposed here, which again is substantially less impactful than all of the surrounding land uses in this area. And, that is, to say it's different from someone who has one or two storage units, I think it may be, but that doesn't make it more impactful. It doesn't make it an inappropriate land use in this area. And I think the board certainly has the discretion to look at a very broad, undefined category of allowable land use, like light industrial, as including storage.
But Attorney Silverstein, my issue is what's to prevent the guy across the street who has an oil change business or an abandoned garage that's up on 6A, I'm not sure how familiar you are with the town, from when, if we were to allow this, go, hey, I'm gonna throw some storage trailers up because they let them, why can't I? And next thing you know, we've got storage trailers going up for people who don't know what else to do with their property. This could set a precedent that I would really make the town look ugly if people threw these up in all sorts of general business areas, because that's a large section of, you know, retail and that kind of thing. So I get it.
Your question.
I'm just concerned, that's a precedent that doesn't help the image of the town. And I agree, there are probably trailers where they shouldn't be. But I also, like we've said, we have no evidence that they've rented them out, which is what your client wants to do. So there is a difference between throwing one up my property, and I don't know why neighbors don't get a little bit more ambitious about having their neighbors remove those things. But, so I'm concerned with that, by providing this permit, that somebody else is gonna use it to go do that. And there's a prime piece of property right on 6A downtown, Ted's Garage, you all know it. Big chunk of land there, he could throw a bunch of trailers up. And I don't know how we could stop that if we let your client do this.
No, I appreciate your question. It's a legitimate concern, but I think I can easily set your mind at ease on that, hopefully. If the board accepts my premise that this is allowable as similar, say, to a contractor's yard, or, you know, approvable within the very broad category of light industrial, I'll note that those are both uses that require special permits. So it's not something that, you know, someone who has a property that has not previously been used for storage could just do. We're asking the board to approve a special permit here. I'm saying this is not a use that's prohibited, and that would require a use variance. But that doesn't leave the board without any control. I'll also note, to your point, in terms of, you know, what the property looks like, this property was littered with junk, rusted trailers, old boats, all sorts of other detritus, all of which was cleaned up and removed by my client. I would say that the property right now looks much better. And that's if you actually go back behind the building, because you can't see any of this from the street. And so I don't think there's a concern as to this property that this is, you know, gonna negatively impact the look of the town. And, you know, respectfully, I would suggest that if that's a concern, it's the neighboring properties on the other side that should be asked to clean up a little bit, because this property is in immaculate condition, and the storage units are not visible from the street. And that's, you know, going to my point, if the property across the street were to come to you and ask to put up a bunch of storage units in the front of the property that were visible and that were unsightly, that would be easily distinguishable from the situation we have here.
Mr. Silverstein, your applicant didn't come and ask to do this. He did this, and he's asking for relief after the fact.
That's I take your point.
No, I'm just, your analogy doesn't fit.
It's not an analogy. You're asking, I was trying to address your concern that this could happen all over town without any controls by the board. And I'm trying to look prospectively and be mindful of the chair's admonition that, you know, we should treat this as a blank slate going forward. I don't want to, and I don't think it's helpful to argue about what has happened in the past and what should or shouldn't have happened. I'm here now on behalf of the applicant asking for zoning relief and explaining why I think the board has the authority and should grant that zoning relief.
Okay, let me take a pause here and say that I'm getting a sense of where things are going in the board. What I would like to do is to switch the focus and see if there's anyone in the public, in the hall, in the room there. I know there's this one individual there in the room with you. And I'm asking Peggy, is there anybody, let me start with the virtual world. Peggy, is there anybody out there seeking to speak on this issue?
We have many attendees, but no hands raised.
No hands raised. All right, very good. Is there anyone in the room? Now, again, we're limiting ourselves to the appeal of the building commissioner's order. We're not looking for comments yet on a special permit or a variance. It's strictly on the appeal of the commissioner's order. Is there anyone in the room there who wishes to speak on this issue? Nobody.
No.
I'm getting a sense of the board. I'll go back to questions unless someone wants to entertain a motion.
I just have one quick question for the attorney,
Sure.
please.
Sure.
We've been talking about the references you've been giving for, potential ways for this to be considered and allowed use in town under some way, shape, and form have been contractor yard and light industry and manufacturing, as you noted, both of which requiring special permits. As it relates to the zoning Davis's position that the current use is not allowed, do you see any use that we should be considering here that is allowed not under special permit or a use variance? If there's none that we think it could qualify under, I think we could probably skip to the next part. But if we think there's a way for us, if we think there's a way for this, that this is allowed by right, I guess is what I'm getting at. Is there a path for us to even overturn it at this point?
So I'm going to say yes, but that is not going to be my focus. So in terms of this being allowed by right, I would not say there's any category. There are actually very few categories of uses allowed by right in the general business zone. But I wouldn't say that this use fits within any of them. I have and could make an argument that that storage uses have existed on the property and should be considered pre-existing non-conforming uses. I don't think I'm likely to convince you of that, and I don't think it's productive for me to focus on that. So I want to be really clear what I'm advocating in terms of overturning the building commissioner's order with respect to number 1. I'm not waiving my position that no relief is required, but I don't think it's productive for me to focus on that to you. What I'm focusing on is his determination that a use variance is required, as opposed to a special permit.
I have a question. Number 1, the term storage, but we have 2 different situations. There's the building.
If I don't challenge that determination, I waive it. And what I'm looking for the board to determine is that this is a use that it can allow by special permit. And I think in the next phase of this discussion, I've gone into some detail as to why I think it's allowed as a specifically listed use in the table of uses by special permit. But I think frankly, the clearer and even stronger argument is that the current or historic use of the property has been non-conforming, and that the board has the authority to allow the proposed use as an alteration of the pre-existing non-conforming use. I don't want to jump ahead, but I'm just trying to explain.
Do you have evidence?
What I'm asking you to do is determine that a use variance is not allowed under the first category.
Do you have evidence that the building actually had leases where it said the use of the office space, which that's what the building was going to be used for storage? I know you referenced Cape Cod 5 in here, but I don't know if they rented it as office space and decided to put a bunch of boxes in it. Do you have proof that it really was non-conforming use as a storage facility?
Well, we're getting ahead of ourselves. That's an issue for the next hearing.
I'm trying to separate the storage containers from the building. To me, it's very difficult because they're just one line. And it's two different ways of doing storage, so I'm having difficulty pulling it apart. Because I'd like to have something favorable come out here, but if you just took that as storage, I have a problem.
I understand, and as I said, I'm not planning on focusing before this board on there having been a pre-existing non-conforming storage use of the property. Because I don't think that is something that I'm going to convince the board of, and I don't need to. But again, I think the chair is going to point out correctly that that's really coming in the next part of the discussion. Really, I only raised it for the purpose of clarifying what I'm asking this board to determine with respect to that first zoning violation in the order. And it's...
May I ask you a question? Are you thinking of withdrawing your appeal of the petitioner's order and applying for a special permit directly?
I'm sorry, so no, I've requested alternative forms of relief.
Right.
The first part is that we're appealing the building inspector's order. As I said, I'm not waiving the argument that this is an allowed use, but I also don't think it's going to be productive to focus on it. So what I'm focusing on, and what I would ask the board to do with respect to the first of those 5 violations, or the first of those 5 zoning violations found, where the building commissioner in his April 18, 2024 order states that a variance is required, I'm asking the board to overturn the determination that a variance is required, that this is a prohibited use, so that we can then get to the next phase of the discussion, which is the request for a special permit.
I'm confused. Aren't we just addressing the issuance by Davis that storage is not allowed right now? I don't want to get into.
I think the issue is, David, that the order goes a little beyond that. It says that not only is storage not allowed, the only way it could be allowed is to get a variance.
I understand that, and Mr. Silverstein's applied for a variance. That's his third.
He's also applied for a special permit.
I understand that as well, but
I
before.
think he's arguing that he thinks his case for a special permit may be strongest of all.
Well, that remains to be seen. Aren't we just dealing with
Clear.
Davis's order right now? I thought we were-
are, but, go ahead, Mr. Ford.
Yeah, if I might just say something that might help the board here. So you're standing in the shoes of the building commissioner at this point. When you hear an appeal of his decision, you have a right, under the statute, to make any decision that the building inspector could have made. I think what the applicant is asking you is not that he's waiving his right to contest it, but he's saying, I hear where the board is, and if the board decides to uphold the decision of the building commissioner, I would ask that you do so with one change, and that is that storage is not a permitted use in this district as opposed to prohibited. By finding that it's not permitted, you would at least leave him the opportunity to argue the special permit case. Doesn't mean you're gonna grant it, but it puts him in a different position. I think that's what he's asking you at this point. I'll let him speak for himself, but you have a right to make amendments to the building commission's decision. It's not straight up or down. You stand in the shoes of the building commissioner. And if you decide, having heard what the testimony is, that number one should be storage is not a permitted use, then you simply give him the opportunity to argue the special permit. Don't have to do that, but that's what I think I hear the request being.
I think it's black and white. I think the only alternative for the applicant is a variance.
So to restate that, Attorney Ford, we're basically saying that we agree or disagree with the statement that Mr. Walters wrote, storage is prohibited in use in the general business district. That we either agree or disagree. And if we were to agree, then we're upholding what Mr. Davis wrote. If we disagree, then we can move on to a variance.
Yeah.
Or
but
a
you
special
might-
permit, whatever difference.
Right, but you want to make sure that if you disagree, you're not saying it's permitted.
Right,
Okay.
In other words, what's the extent to which you disagree? Maybe your finding is that storage is not permitted, not that it's prohibited.
So
I see that it's not permitted as a special permit use. It's only permitted, or a variance will be needed. It's not permitted by special permit.
And Mr. Little, you got every right to make that determination. I'm just telling you, you've got broad discretion here. You can vote it exactly the way Davis has got it. That's your decision.
But
And you
the
can-
applicant, if we were to agree with the statement, the applicant can still file for a special permit or variance. We're not ending this whole conversation.
No,
Well, no, he can apply for a special
Okay.
permit, but it makes it more difficult for him because you've upheld the finding that storage, and you're considering the storage, is a prohibited use. And prohibited uses are not allowed by special permits.
But it can be by a variance.
Right.
yes.
But it can be a variance. Okay, well, that's one of the
It could be a
options. So we're not
Yes, it could.
shutting the whole thing down. Okay, I just,
You're correct.
Okay.
You're correct.
okay, thank you. Sorry for all that confusion. Took me a while to get there.
All right.
And you might want to let Mr. Stilbestein address that. I didn't mean to take you off track. I just wanted you to realize that in reviewing a decision of the building commission, you stand in his shoes.
Thank you.
If I could just briefly, Mr. Chair.
Please.
So, Mr. Ford's 100% correct. My argument, what I'm asking the board to do, is not to determine that this is a use that's allowed by right. Rather, I'm asking the board to determine, as I've argued, that it could approve this use as a special permit use under one of those other categories that we've already discussed, light industrial, contractor yard, that it could approve a special permit. Just, to be clear, and I'm not gonna go into depth on this now, in my submission, I offered two separate bases to request a special permit. One is under those use categories. The other is as an alteration of a pre-existing non-conforming use. So I think if the determination that this is a prohibited use that requires a use variance in the general business district is upheld, then I'm assuming the board would not entertain the request for a special permit within one of those other use categories. But that would not, and I don't want to, I'll let Mr. Ford jump in if he thinks I'm misspeaking here, that would not preclude me from making the case of this being allowable by special permit as an alteration of a pre-existing non-conforming use.
No, I don't think it prohibits you from making either one of your special permit arguments. I don't think you've lost either one of them. So to at least present them and let the board decide.
Agreed.
Good.
Let me jump here if I may. David, I want to respond to your comment that you think variance is the only avenue. I think.
Well, I'm just showing my cards ahead of time, that's all.
Well, I know, and I'll show mine ahead of time, and then I think that the applicant has made a very, very tolerable argument for lawful non-compliance. It's been, this property has been used for storage, and it's been a lawful non-compliance.
Well, but we're not addressing that right now.
No, we are, because if we use the word prohibited, then it can't be a lawful non-compliance.
Well, then maybe we should,
If it's not permitted, it's allowed.
then maybe we should discuss what renting a space and storing some boxes in it, whether that's considered storage or not. I think that's a whole different avenue we need to go down.
Well, I think we do that in the special permit consideration.
That's what I'm saying.
Right. So the
I-
issue is,
I'm just telling you, I think the zoning bylaw is black and white,
Correct.
the way that I read it. And I'm just showing my cards as we go for the next two items, for the special permit request and the variance. I'm not saying he can't request a special permit. I'm just saying I'd like to move forward and move that we uphold Davis's.
if we uphold Davis's order with the word prohibited use, he's precluded from the special permit.
No, he's not. He's not precluded from presenting his case, Mr. Chairman.
Well, I think we're precluded from granting it, aren't we?
Well, I defer to Mike Ford on that.
No, I don't think you are. This hearing isn't over until the public hearing is closed. You would have a right to look at all avenues of relief. And to the extent that you felt in acting on the special permit, that you wanted to reopen the building permit case and make a modification to it, you'd be within your right to do that during the same public hearing, Mr. Chairman.
But we lose nothing by changing the language except to permitted. Makes it easier, we have to go back and reopen the hearing. But my view is that we should have a full hearing on the special permit, and if we don't get to a special permit, we could go to a variance. That's the rule, that's how we set the rules tonight. But it seems to me that if we haven't, we've increased the hurdle for a special permit by adopting the language of prohibited use as opposed to not permitted use.
Storage, it's black and white to me, Mr. Chairman. Storage is a prohibited use.
Correct.
I don't see it any other way.
No? Okay.
Big P, right in there.
Well, we have a motion then.
Mr. Chair, we have an audience member who's looking to speak.
I'm sorry,
No,
okay.
no, I'm gonna withdraw my,
It's been withdrawn.
We need a motion?
Well, what's your pleasure then, gentlemen and lady?
Can I get clarification? We are are we going to separate our decisions and our votes on a per number basis of the 5 items that Davis has identified? Or are we going
No.
all or nothing, or identifying the specific line items we agree with?
I think that some of these items,
Have been corrected.
1 through 5, will have to, may be addressed in the special permit request, or may be addressed in the variance request.
I'm not sure we have a role in number 5.
Okay, 1 through 4. I mean, I'm just, is storage a prohibited use or not? I think that's where we are.
To uphold the Walters' decision or not.
Yes.
Yeah, we need to make a motion for that.
But I'd like to just make clarification that I think at this point, I believe, and I think we all may believe, that the parking item that was noted should not be upheld. So I want to make it clear what we are actually voting on here.
But he said parking spaces may violate parking requirements, not
Yeah.
does violate.
I think I would prefer, and maybe I'll leave it up to the chair, that we should address each of the items since they're presented separately. But fair
Okay.
point, David, that it's not, there's not as definitive language in that as there is in the first, but I think I'd just like to make it clear what our determination is on a per line item basis.
Okay, no, I'm good with that.
Mr. Ford, you want to opine on that? The only thing
No,
I might want-
you have a right to, take them separately and make any decision that you feel you should make.
All right, why don't we agree that 5 has no concern for us? We don't have any role in that,
Correct.
in number 5. I'm gonna do them in reverse order because we're in a discussion, I think, on number 1. Why don't we have a motion, all right, so the idea is we'll have 4 motions to uphold the building commissioner's order as written. First one, let's start with number 4. I don't think there'll be any issues. Do I have a motion to uphold the building commissioner's order on the 4th condition?
It says appear to violate setback and screening requirements. That's something that would be addressed in a site plan review hearing that the applicant admits he's going to have to go to.
I think, yeah.
I was on the property outside. It appears that the storage units have been moved to comply with setback requirements. I peeked over the fence from the neighbor's property to take a look, so I think that may be a moot point now, but it's something the site plan review deals with, not us.
I think the client has corrected that.
So we're not gonna, so we just don't, so we don't adopt that.
That's why I don't want to.
So I don't know if that confuses
No,
this.
it's-
We still
Just do
uphold
one.
it because he actually moved it. So this in fact is a correct statement. It must have violated the setback and screening, otherwise the client wouldn't have moved the containers. I would.
Why don't we motion, please, Mr. Sillison, you want to?
All right, I just want to clarify that they were moved to comply with the request of the Conservation Commission, not because it was in violation of any zoning
So
setback.
it's nothing to worry about, or it's nothing for us to deal with anymore, is what we're saying.
Right, so do we have a motion to uphold the commissioner's finding or not uphold the commissioner's finding in number 4?
I motion that we uphold the commissioner's findings.
Who made that?
I did Martin Saber.
Oh, Martin, yeah, okay.
Second.
Is there a second?
Second.
Second? That's David? All right. Any more consideration, any more discussion of it? I'll call the roll. Sibel,
Aye.
Austin,
No.
David,
Yes.
Martin,
Yes.
and I'm also a yes, so it passes 4-0.
Done.
Number 3, is there a motion to uphold the removing parking spaces may violate the parking requirements? I'll move to approve that.
I'll second that.
Okay, that's,
I just, a discussion on that, Mr. Chairman?
yes, please do.
I think the document provided put a pretty clear argument together that the parking spaces are okay, that it's not in violation.
I agree with that.
I agree.
So, okay, so we can vote on that now.
So we
I just,
voted, it no longer matters? How do we proceed?
I'll motion that we,
Wait, hold on, let me ask Mr. Ford, do we just vote to uphold it or not?
Is the motion to uphold number 3?
Yeah,
yes.
no, there's no
Then-
motion made, it's either
Oh,
uphold
there
it.
isn't, okay.
The discussion is it's moot.
Well, that's my,
You could, or you could
I,
overturn it. You could overturn it. You
all
could
right, then
move
my
to-
motion is that we overturn item number 3 in
But
Mr.
don't we
Davis's
wanna ask
document.
Davis to see if he agrees that it's a moot, that it's
Okay.
not a issue?
Davis, you want to orate on that?
Well, I do agree. I want to be clear that the purpose of the matter being handed over to the board is that it's your decision and not mine at this point, but thanks for asking, I do agree.
With the wording of it, that parking spaces may violate parking requirements, I don't think it really matters what we do, one way or the other. I'm comfortable with a yay or a nay.
All right, which way do you want to do it? Who's?
I think
I think we just strike it.
I think we agree his wording. There's
Yeah.
nothing wrong with the way that he worded it.
I just think we should remove it from the record effectively, because it's not, we don't think it's relevant. Right, so I motion to overturn bullet number 3, removing parking spaces.
Okay, any more discussion, is there a second on that?
I'll second that.
All right. Any more discussion on it? Let's have a vote. Mr. Bell?
I'm a little confused. I agree with,
We're voting overturn it.
I don't think we need to overturn it. So I guess I would be a no, which is weird because it's two negatives.
We do a lot of weird things here, Isabel. Austin?
I mean, I guess functionally, I don't know if it really matters, but I think it's a cleaner slate if we just remove it from the discussion completely.
So that
I
was-
see no harm in us removing it, and I can see there could be potential headaches to keep it.
So you're voting yes, because that was the motion to remove it.
Motion is to remove.
I vote yes,
overturn number 3.
I vote yes because ultimately this is gonna be going before site plan review and that will all come out in the wash. So I vote yes on removing it.
I vote yes
Do
also.
we get a formal second for Hector?
I second it.
Yes, he seconded
I
it.
second it.
We did. All right, and I'm also, so that's
I'm a yes.
4-0. 4-1. And it passes. The change of use greater than 1,000 square feet requires site plan committee approval.
I-
Have a motion on that.
I would like to keep this, while I believe it to be factual, I think whether or not this is relevant will come out when we talk about things later on tonight. So I vote to, I motion to uphold bullet point number 2.
I second that.
Is that David?
Yes.
Okay. Any discussion? Sibel?
Yes,
Austin?
Yes.
David?
Yes.
Martin?
Yes.
And I'm also a yes, that's 5-0. Now, on the storage and prohibited use in the general business district. David, you want to make a motion?
Yes, I move to uphold the building inspector's determination.
I'll second that.
All right, I would argue against it. I'd like to see the word being not permitted to allow an easier hearing for the special permit. I'm convinced that there may be some merit to a long-standing non-compliance
But
on that property.
I believe the applicant still has the opportunity to make his case for that with a special permit.
Well, I thought Mr. Ford told us that we would have to go back and undo this vote if we voted it as a prohibited use. Is that your ruling, Mr. Ford?
I don't make rulings, I just give advice. But otherwise, you're going to end up with conflicting findings, so.
So where does, Mr. Ford, where does alteration or extension of a lawfully pre-existing non-conforming use come into play with Davis Walters' findings?
Davis has made a finding that you need a use variance. He says this is a prohibited use and you need a use variance. I think his actual decision used that. I'm not sure that it's listed in the paperwork that Mr. Silverstein has filed.
The schedule of regulations uses the term use prohibited.
Yes.
I mean, I think that's where Mr. Walters was coming from when he used
That's right.
his words. So it's,
That's right, that's where he was coming from. He
so I
believes
don't know how that
he-
isn't the right word.
Yeah, oh, well, and it may well be. I'm just suggesting to you that you have a right to stand in his shoes and make whatever decision he
Okay.
could have made. Now, he made the prohibited one. If you agree with that, then you should vote to uphold him. I'm not suggesting
Okay.
otherwise.
Can I make a comment? I would like to just make note that there is wording in the schedule of use table for prohibited, and it is explicitly prohibited. Not being in the use table, which storage as it currently is defined is not in the schedule of use table, does not, in my opinion, make it inherently prohibited. It does not make it a it's not in the table. 164.10 specifies that no building structure or land shall be used for any purpose or in any manner other than as permitted and set forth in the schedule of use regulation. I see storage as not being prohibited, but it is not an allowed use as is. And I see those as two different things. We have permissive zoning here and not fully restrictive zoning. And I think that hearing this as a special permit or giving the applicant the ability to pitch this as a special permit, I think there's still merit in doing that. If storage was explicitly listed as a prohibited use, ignoring discussions about trailers or whatnot, it's not prohibited in my eyes, especially if there are paths where light industry or manufacturing or contractor yard is an allowed use, but it still requires a special permit. So as it currently stands, it's non-conforming. Whether or not a special permit can be issued to make it a conforming use, I think is what we still need to determine. So my preference is to overturn the decision and say that the use is currently non-conforming, which would still require it to, at that point it would not conform to the zoning bylaws, and would still require a special permit or a variance. But it's not, in my eyes, prohibited, because it's not explicitly labeled as such.
I'm
Mr.
okay with
Chair,
that.
though, I'm a little confused. Wasn't there a motion put and then I seconded the motion?
And then we're discussing it right
Yeah.
now. So we're going through that discussion.
I have no objection to what Austin said.
Davis, do you want to speak?
Yes, Mr. Chair, thank you. I'm sorry to interrupt the discussion, and I'm sorry for being late to the process with this comment. Well, it's not a comment, but I just, for the record, I would like to point out to the board that in the use tables, wholesale and storage only has two examples that Mr. Silverstein had pointed out earlier: sale of fishing bait, fish and shellfish, and then wholesale business. But I want to point out to the board that in 164.4 definitions, there is a definition listed, wholesale business / warehouse, in which it is defined as a use engaged in storage, wholesale, and distribution of manufactured products, supplies, and equipment, but excluding bulk storage of materials that are flammable or explosive or that create hazardous or commonly recognized offensive conditions. So storage is referred specifically in the definition that is referenced in the table. I just wanted to point that out, that was part of the information behind my reasoning. Thank you.
Could you clarify, Davis, the definition, which definition line item that was again? I missed it.
wholesale business warehouse,
A wholesale business / warehouses, it's,
9 of 76.
Page 9.
Perfect, thank you.
Yeah, now it includes warehouse.
and I apologize for bringing that to the board's attention out of order. I apologize to Mr. Silverstein for delivering that late, but been looking for an opportunity to insert that in the discussion.
Can someone explain to me the difference between a special permit and a variance? The technical
Yeah, I can,
difference?
Mr. Chairman.
Yeah, please do.
I can, Mr. Chairman.
Please do,
So-
Mr. Wood.
A special permit is generally something that is conditionally allowed. And it's not allowed as a matter of right, but requires a public hearing before the zoning board of appeals. There is special permit criteria, both general and sometimes specific. And if the board, after that hearing, finds that you can meet all of the performance standards that are required for the issuance of a special permit, it can be issued. The variance, on the other hand, is something that is prohibited, either dimensionally or by use, under the zoning bylaw. And in order to be entitled to a variance, you've got to meet a strict statutory test under Chapter 48, Section 10. There's got to be some unique conditions
Okay.
that relate to your lot, but not generally the other lots in the zoning district, relating to soil, shape, or topography of the land or structures located on the lot,
Hardship.
such that if you apply the bylaw literally, it creates a hardship, financial or otherwise. So the variance test is much more stringent, much more difficult to meet than the special permit test. Specially permitted uses are uses that are allowed in the bylaw, but only after hearing by the Board of Appeals and the decision by the board that you meet all the criteria for a special permit. That's the distinction.
Thank you. I understand now. I understand why we're having this discussion between permit and
So-
variance.
And one of the provisions of the variance, you can look it up in the bylaw, relates to soil conditions in the lot.
So could I ask Davis a question, Mr. Chairman?
What's that?
So Davis, the definition for wholesale business warehouse, would you interpret that the rental of storage units would fall under that category? My reading of that, I see a
All I'm
whole,
suggesting, I'm sorry, David, all I'm suggesting is that that there is a reference in the definition to describe the use that's shown in the table.
yes.
There's no descriptions in the, no descriptions per se in the uses that are listed in the table, but there is a description related to this use, and it is a prohibited use in the general business district. That's the only point I'm trying to make, is that Mr. Silverstein, if I'm not mistaken, characterized this use category as somewhat nebulous or undefined, and it is defined.
Yeah, thank you, Davis.
Could I jump in just real quickly, Mr. Chair?
Please do.
So, no, I don't think that the term wholesale business is nebulous or undefined, and I do specifically address this in my submission. And I say that I don't think that definition applies because the definition of a wholesale business is a use engaged in storage, wholesale, and distribution of manufactured products, supplies, and equipment. That is conjunctive, not disjunctive, meaning a wholesale business stores and distributes manufactured products. It does so at wholesale. Clearly what we have here is not a wholesale business. No one could argue that the proposal to rent storage units to customers is a wholesale business. And so I specifically in my submission say that category clearly is inapplicable. I don't think anyone would suggest, I don't think Mr. Walters is suggesting that,
I don't know.
this is a wholesale business. And it would make sense that that type of business would be prohibited in the general business district because those businesses involve large tractor trailers, loading bays, late night trips from, the airport or shipping facilities. That's why, obviously, you don't want that sort of use in a business district as opposed to what this is. Mr. Walters, I think, is remembering my reference to the broad, undefined category of light industry, which is a nebulous, sort of catch-all category that I think this proposed use could fit within, and which the bylaw does not define in any way, and I think the board could certainly interpret to encompass this proposed use. And that's the basis for my special permit request, separate from the alteration of a pre-existing non-conforming use. I have two different bases for requesting a special permit. One is the alteration of a pre-existing non-conforming use, and I know we're not talking about that right now. And the second is that even if this weren't going to be allowed as an alteration of pre-existing non-conforming use, I do think the board has the discretion to approve it within the broad, undefined category of light industry.
Okay, so that being said, Mr. Chairman, I'm going to stand by my original motion.
All right, let me just, for benefit of Martin, let me read this one provision of the variance requirement to further discussion of the difference between variance and a special permit. Section B of 164:43. The hardship is owing to circumstances relating to the soil conditions, shape, or topography of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located. A very high standard. I don't want to, I guess that's showing my cards, as David would say earlier in the hearing. Here we are. So, do we have a motion on this first one?
I think we have a vote.
We have a motion and a second to uphold Davis Walters'
Okay.
decision.
Language as written,
Yes,
prohibited, okay. Is that, who made that motion?
I did.
David? And who seconded?
I seconded.
Sibel. Okay. Let me call the roll. Sibel?
Yes.
Austin?
No.
David?
Yes.
Martin?
Yes.
Okay, and I'm a no. So it's 3-2. So that fails.
No, that doesn't
No,
fail.
it doesn't fail.
It takes 4 votes to overturn the decision of the building commissioner.
Takes 4 votes. Okay.
Yeah, and 3 voted in favor of him, so he's upheld on that issue.
Okay. Is there anything else we have to do on this portion of the hearing, or does this close the hearing?
I don't think you should close the hearing. You've opened the hearing, and there are 3 alternative forms of relief that the applicant's trying to
Close
present
this
to you.
portion of the hearing, I'm sorry, I misstated. Close this portion of the hearing and move to the application for special permit.
Correct.
All right, Mr. Silverstein, you want to make a presentation for a special
Sure,
permit?
thank you, Mr. Chair. So, as I've said, there are 2 separate and independent bases for my request for special permit. The first, I think we've discussed at some length already, which is that, as I just said.
Excuse me a second, Mr. Ford, can you go back to that vote? The vote was 3-2 in favor of upholding the building commissioners. So the vote failed if we didn't uphold this vote.
No, it takes 4 votes to overturn the building commissioner under the statute. The building commissioner gets 2 votes, he's upheld.
Okay, I
In
got
this
it.
case, he got 3.
I got it. I had it backwards. I just thought the motion failed. because
Yeah,
form
it's just the
was-
opposite.
It's the reverse in that case. I
Right.
understand. I apologize.
Can I
Mr.
just ask Mr. Silverstein one question? Mr. Silverstein, I know you're starting on your special permit aspect.
Yes.
And you said a couple of times that you'd be willing to go to site plan review if the board is inclined to granting a special permit or a variance for that matter.
Right.
The bylaw, I think, specifically provides that they can't grant a special permit unless you've gone to site plan review. I don't know whether it makes any sense to go to site plan review before you continue with this particular presentation for a special permit.
Well, I
Just leave
guess,
that as an option to you.
yeah. I guess on that point, I would be, it would be helpful to have a sense of the board at least,
Yeah, okay.
before we spend a lot of time and money going through site plan review. I guess I haven't looked specifically at, as you know, a section 6 special permit to alter a pre-existing non-conforming use, I think is somewhat different in kind, and perhaps that would provide some
Okay,
some flexibility in that regard. Or the board could take a vote conditional on going through site plan review and not finalize and file the decision until we've done it.
maybe that makes more sense, I agree. Yep,
Okay.
yep. So, Mr. Chairman, what he's saying is that if he puts a special permit in and the board is inclined to perhaps grant relief before they took that vote, then there might be an opportunity for a continuance for him to go and get the site plan review done, come back, get that in the public hearing, and then continue the hearing. But what he's saying is until he sees that that opportunity might be available, or maybe he can convince you under the non-conforming section, so he wants to proceed.
I understand that, Mr. Ford, but if we are inclined to grant a special permit, we have to go back and re-vote the last vote on the first line of the building commissioner's order.
It would be cleaner if you did.
Are
At
we
that
allowed,
point.
the question is, are you allowed to grant a special permit for prohibited activity?
Generally, no. Generally, it's only allowed under a use variance for a use that's prohibited. So you'd have inconsistent findings.
Does it make sense then to go to the variance and put the special permit later?
I would ask the applicant how he would like to proceed. He's filed it in order, and I think he's got a right to submit it, to argue them in order.
I agree, and we agreed to that at the beginning of the hearing.
Right.
I guess if I could, Mr. Chair, I think that, as I said, I've offered 2 separate and independent bases for requesting a special permit. One is, as we've discussed, that I think this could fit within use categories listed as being allowable by special permit. I think if the board were to grant a special permit for this proposed use, for instance, under the umbrella of light industry, that would be somewhat inconsistent with the vote you just took. The vote, I don't think, would be inconsistent with my other ground for asking for a special permit, which is as an alteration of a pre-existing non-conforming use, because Mr. Walters' enforcement order simply says that the use is prohibited in the district and can only be allowed by use variance. it doesn't, you know, in fairness to him, no issue of pre-existing non-conforming use had been posed to him when he issued the order, and I don't think the board's decision to uphold the order would preclude it from finding that there is a pre-existing non-conforming use or allowing an alteration of that pre-existing non-conforming use. So obviously, I defer to Mr. Ford as to whether he agrees with me on that, but I don't think your prior vote would preclude issuance of a special permit as an alteration of a pre-existing non-conforming use.
Mr. Chairman, I agree with that reasoning.
That's what I was alluding to earlier, that
Well, let
Under
me
that-
ask you a question. How can it, I understand that a non-conformance, how can it be lawful? A lawful non-conformance?
I think you should let him
Well,
finish.
I'm happy to address
that.
that.
Yeah.
Okay, well, I look forward to being educated. All right.
All right.
Are we, David, did you want to make a comment?
No, based on Mr. Silverstein's comments, I agree that we can hear the special permit request as an alteration or extension of a lawfully pre-existing non-conforming use.
Okay.
Other than that, I don't agree a special permit would be allowed.
Yeah, I await to understand how a prohibited activity can be subsequently deemed to be lawful, but,
Well, he's gonna try and convince us.
Yeah, great. Mr.
All right.
Silverstein,
Thank you, Mr. Chair. So, all of that being said, I'm not going to go back over the special permit as falling within light industry or any other use listed in the use table. So, and mindful that we've been at this for a couple hours now, and appreciative of the board's time, I'm not going to spend a lot of time on, though I do believe we have some evidence that storage, rental of storage to non-office tenants of the property has been a historic use over the years. I don't know that I'm going to convince the board of that, but I do know I don't need to, because there's no dispute that the predominant use of the property since the building was constructed has been as an office use. And the office use is a pre-existing non-conforming use, because under your bylaw, any office use over 2,500 square feet requires a special permit. No special permit was issued or required when the building was built. And so, again, I would defer to Mr. Ford, but I submit that the use that everyone agrees has been at least a primary, if not the only use of the property, the office use of more than 2,500 square feet is a pre-existing lawfully non-conforming use. With that foundation, the board has the ability under the bylaw to allow the extension or alteration of a pre-existing non-conforming use. And I think the board clearly has the discretion to do that here. And I've cited case law that you're a pre-existing non-conforming use not only if you're a prohibited use that predates zoning, or the zoning requirement, but also if you're a special a use that predates a special permit requirement for that use. That's what we are. I don't think anyone would dispute that And then you look at the standard for alteration of a pre-existing non-conforming use, which is whether or not it's substantially more detrimental to the neighborhood. And I think clearly this use, which requires, involves much less traffic and generates much less activity than an office use, and is surrounded by incredibly impactful, loud, more heavily industrial uses. I think clearly the board could find easily that this proposed use is not substantially more detrimental to the neighborhood. And so I know we've spent a lot of time arguing about what is and isn't allowed under the bylaw. And I think it, from an organizational procedural standpoint, we had to address those issues first. But I think this is really a much easier path. And I'll rest there. I don't think I need to belabor the point, other than to say that if the board were even preliminarily or contingently to determine that it would approve a special permit for this alteration of the pre-existing non-conforming use, then we could go through site plan review and confirm that there's, that this won't be substantially more detrimental to the neighborhood. You won't be taking my word for it, though I think logically we could all agree that it is the case.
So because the building predates basically the application of a zoning code in Orleans, so it's therefore non-conforming.
Correct.
So that every building that predates zoning is non-conforming?
If it is a use that predates the zoning requirement and that doesn't comply with the zoning requirement, it's considered that's the definition of a lawfully pre-existing non-conforming use.
Okay, so its use as an office building was a non-conforming use. And once you have one non-conforming use, your point is that any other use you make of it can inherit that non-conformance?
By a special permit from the board.
You also have a colorable argument about secondary use as a storage, don't you?
Absolutely, and again, I don't want my not focusing on that argument in any way to suggest I don't believe it's a strong argument. I just, reading the board, frankly, I don't think it's an argument that would convince 4 of the 5 members. We have some evidence, and if we had to go through litigation, we think we could amass a lot more evidence that at least one business that never rented office space was renting storage space on the property. There was a lot of other material and items being stored in the back of the property. There's a storage container that was partially on the property that was being rented to others. But I've avoided that discussion, frankly, because my sense of the board is that it wouldn't be, I wouldn't be able to convince 4 out of the 5 members that the storage use is a pre-existing non-conforming use. I think there's a very strong argument for that, but I really don't think we need to get there because, and again, you don't have to take my word for it. Obviously, if Mr. Ford disagrees with me, then I'll refocus on the historic storage use. But I think it's quite clear to me that the historic office use is a pre-existing non-conforming use, and that's the easier path.
Does-
Austin, you have a question?
Yeah, I just want to get some clarity from Davis. At what year or years did zoning become codified in the town of Orleans? When we talk about something being legally pre-existing non-conforming by predating zoning, what is the cutoff year we would generally?
I believe it's, was a bit of an ongoing process. I'd have to defer to Mr. Ford for a range of dates.
I just want to just lay out clearly and straight the nature of the lawful nonconformance.
So,
If I could
if I may,
just, oh, sorry.
if I may, Mr. Chairman,
Please.
our zoning book cites a date of 1971, but there was zoning in town before that. This building was built sometime around 1980. The argument, as I understand that Mr. Silverstein made, was not that the office building was built before zoning was adopted in Orleans. The office building was built before the requirement that any building that contained more than 2,500 square feet of office space required a special permit. And so this building was built back when, yes, there was zoning, but it was built as a matter of right. There was no special permit requirement. Subsequently, a special permit requirement came in for anything over 2,500 square feet, this being 12,000 plus. It's non-conforming as to that requirement for a special permit. And then he cited a case which says that something that exists today, which now requires a special permit, and existed as of right before the special permit requirement, is considered to be pre-existing lawfully non-conforming under the provisions of Chapter 48, Section 6. And so that's the argument.
And I agree with that. What I was trying to get clarity on is, was the addition of that requirement for a special permit above 2,500 before or after the date of this building's creation?
I don't
I think-
know that off the top of my head.
Yeah.
Perhaps council researched that, did you, Mr. Silverstein?
I attempted to, but there really wasn't much available. I guess what I would say is this: this building isn't hidden. It's right on a main drag. And I think it's a reasonable inference that a building that was constructed in plain sight of the street by a longtime family involved in local governance wasn't constructed in blatant violation of
Yeah.
such a clear requirement.
Yeah, I think where I'm getting with this, apologies to cut you off, is this sort of special permit to intensify or alter nonconformance is generally used for things like side setbacks, building heights, dimensional requirements, and these sorts of, changing use to a separate, whether it's prohibited or disallowed, I guess we decided it was prohibited use in town, is not something that I'm aware of we do very commonly. So I want to make sure it's clear that what the nature of the pre-existing or the lawfully non-conforming site is, whether or not it was, like you had referenced, Attorney Ford, the requirement was introduced after the building being built, certainly it would be lawfully non-conforming at that point, or alternatively, still lawfully non-conforming, is it was built in violation, intentional or otherwise, and it reached that, 10-year criteria
You're
where
down to Chapter 48, Section 7.
Section 7,
Become
paragraph
part of
3, would make it
Correct.
lawfully non-conforming. I just want to make sure we're clear the nature of the lawful non-conformance, so there's no holes in something that we don't do very often, and have not, to my understanding, done very often. If it was something that was, done in violation of zoning, and became lawfully non-conforming, I don't really know what the burden of proof is for whether or not it was ever brought to, like, there were complaints filed with the registry of deeds or anything. I assume it's something we could potentially figure out. I just, again, out of abundance of caution, want to just make sure whatever we decide here today is, we're doing it under the power we're actually able to do.
Exactly, which is another reason why, if the board is inclined to entertain the special permit request, that I would strongly suggest that you gotta send them the site plan review before you can issue the special permit, because section 6 under special permit, Roman numeral 6 under 16433 says, no building permit, special permit, or occupancy permit shall be issued for any activity used herein unless a site plan review has been approved. So, granting a special permit, I'd suggest a condition preceding to it is something that was required to go to site plan, which David said it was. You upheld that finding earlier tonight. Seems to me that's a base that has to be touched. And to continue the hearing to allow that base to be touched would allow us to also come up with the exact date of the footnote that required the special permit. So you'd feel more comfortable with the findings that you would need to make otherwise.
Could I just jump in real quickly, Mr. Chair?
Please do.
So, and again, I have no issue, if the board, whether it's by straw vote or contingent vote or, you know, some clear indication that we wouldn't be spinning our wheels by going through site plan review. I have no issue with sort of putting this over to allow that to happen. In terms of, and I certainly I appreciate that the more common scenario is someone seeks a special permit to alter pre-existing non-conforming structure. But the bylaw and this statute specifically do allow for that sort of relief in terms of use as well. And I've cited the case law, and you know the statute's clear, and you've heard from your counsel that is within the board's discretion. So you know, I just wanted to address that point. I appreciate that it's less common as something that comes up than a non-conforming structure, but the standard is the same, the process is the same.
All right, let me pause here and speak to the board, ask if there's any questions. If everybody understands where we are, where we, or what's before us. Basically, if you read, I'll just refer to the bylaw, just understand our own bylaw, and 164, section 3(2), I guess it's 3(c)(2), clearly states that other non-conforming structures or uses may be altered. It's pretty clear that that's how I read that section, and then that gives us the authority to grant a special permit if the rest of the standards of the special permit are met. Is that a fair statement, Mr. Ford?
It is.
So, and I think what council is asking, and I think it's a fair question, to get a sense of the board, I guess we ought to look at the standards of the special permit and see if anyone clearly, I think the issue is whether it will derogate from the vicinity of the neighboring properties. And given what's next door, that's a hard argument to make, that it would. But you want to go to 164, 44,
Well,
look at the
Well,
standards?
the test here really is built right into that section,
Yeah,
that the alteration will not be substantially more detrimental to the neighborhood than the existing non-conforming structure or use. That's the test under this section.
Right,
It's also done by way of special permit.
right.
You could look to the general special permit findings as kind of subsidiary findings to help you make your determination as to whether it's substantially more detrimental. But that's the ultimate conclusion that you have to find.
Right.
If I may, though, if I may just ask a question,
Please, Sibel.
isn't it that, I guess I just, need to know if I'm thinking this incorrectly or not. So the way that the council stated it, he said there would be an alteration of the lawful nonconformity of the use, but, which is office. But wouldn't this be not an alteration, but actually a change of use from office to another use? So aren't we wording it incorrectly? It's not, alteration, it's actually a change in the use.
Well, I think what he's saying is that there were tenants that have already used the property as storage. So in fact, it's office and storage non-conforming. Is that correct?
Well, I think just the fact it's a non-conforming office is the only thing, and the way
Right.
I'm reading it is that the alteration, because we always think of the alterations as being, or intensification as being geometric, numerical. Here,
Right.
the alteration is to a different use.
And Mr.
Change,
Silverstein, you
yeah, it's a
mentioned
change
that,
in the
you,
use.
you mentioned you would dig a little bit deeper into the, storage use of the building.
Well,
I don't know if we should.
it's difficult for me to dig further into that. I can tell you that Cape Cod 5 had its own circuit panel. It applied for building permits. It was never an office use there. I feel very confident. It rented what is referred to as the vault in the property. It stored records there. It never had offices there.
Okay.
But, to get more evidence of that would require discovery and litigation, which is exactly what I'm trying to avoid. But I think, and again, I defer to Mr. Ford to confirm this with you, the bylaw uses the term extension or alteration. So again, usually what you're seeing when it's a structure is you're extending it, you're putting up an addition, but alteration is a change. I mean, when you're altering a use, you're either extending it, you're intensifying it, that's an extension. So you're making more widgets, or you're putting an addition on your widget factory. Or you're changing your widget factory to a flower shop. That's an alteration. So, you have to interpret those terms as having distinct meanings. And an extension is an intensification, an alteration is a change.
So is this special permit asking not only to continue the nonconformance, but have it be either an office building and/or storage? Is that what we'd be
No, I think-
granting a special permit? For the building? And I need to separate the building from those storage containers, because I think there's two separate issues, right? So we're just talking about the building, I hope.
Well, again, there has historically been storage and rental of storage space outside of the building as well, and storage of materials and equipment and all sorts of things.
But that's,
But that being the case, and I cited case law to this effect as well, when you have a property, any portion of the property that is used in connection with the pre-existing non-conforming use, the courts use the term, that area has been appropriated to the non-conforming use. So if you're a pre-existing non-conforming earth removal operation or quarry, even areas that you have not previously quarried, if you've enclosed them with fencing and stored equipment and put a road in, the courts view that as having been appropriated to the pre-existing non-conforming use. So here, the fact is the entire property is paved, essentially. The entire property has been used in connection with the pre-existing non-conforming use. And our request is to allow storage on the property. And yes, that would include in the building, it would also include containers in the back of the property. Again, all subject to going through site plan review to make sure that it's done in a way that isn't impactful to the neighborhood, which, again, I think is the ultimate decision or standard, as Mr. Ford indicated, is what we're proposing substantially more detrimental to the neighborhood, and I think that that is
Okay, thank you.
Other questions from the board? Before we go, is there anyone in the audience, Peggy, is there anybody out in the virtual world looking to speak to this issue?
No hands raised?
All right, great. Is there anyone in the room wishes to speak?
There's not.
There's no one.
No. Mr. Zenda has left?
Yes.
All right, other questions. So I think we've had a sort of a reluctance to do straw votes, but we do ask, well, we can discuss it. So are there any questions or comments you want to make about this proposal? Anyone?
I'd be willing to entertain the special permit subsequent to going to site plan review.
I would too. Does anyone else wish to express their opinions or feelings?
I do not like the storage containers. You're not going to like my vote if you include those.
I find myself in agreement with you both, Jerry and David.
Mr. Bell, would you like to opine or not?
I want to somehow find relief for the applicant, although I don't know if the special permit is the path. That to me is pretty, muddy, and I think that there may be a case for the variance. Because I understand that it wouldn't be more detrimental to the neighborhood. That part I understand, it makes sense. And I could see that there's a financial aspect to this, a hardship, that could be perhaps proven. There's nothing in terms of soil, topography, shape.
I think that would end up being a problem, though. I think you'd have to show that in order to grant the variance. I think that would be a
Well,
big
there are
financial
three,
hardship.
right? There are three levels for variances.
Yes.
Yeah.
So hardship is one of them, it's financial or otherwise.
So you have to meet them all.
You have to meet all three.
You have to have a
All three.
hardship, plus you have to have unique conditions, so.
Yeah, because I do want to find a way for the applicant. I just don't see how even the special
Well,
permit really applies.
I do too. I think changing the building usage is fine. I would like to have, I'd like to have the applicant be able to make money on the building. I just find the storage units or those containers are a slippery slope for this town.
I think, like was mentioned earlier by the attorney, this would, it's certainly not precedential, because we do have to, make note that 164-3C2, such alteration will not be substantially more detrimental to the neighborhood than the existing non-conforming structure. If you had someone in a separate part of the general business district who wanted to do the same thing, they may not find that they would qualify for that. All things considered, there's only a very brief period when you're driving by the facility that you're actually able to see any storage units. You'd have to be looking pretty candidly in there. I saw that there was what appeared to be new-ish fencing there when I stopped by earlier today. The site is remarkably clean, and I would hope that that would remain that way throughout its tenure as whatever use it happens to be. And so I think from a precedential standpoint, I don't think there's much to worry about there, because it would have to come through special permit versus making the determination that it's allowed in some other method. And it would require that the current use of that property, potential property that may want to do this, would have to be non-conforming itself.
Already had non-conforming or had storage
Right,
containers.
right. So, no, I'm will, as I said, I'm willing
It's a
to
good
give a
argument.
special
Also.
permit.
All right.
Mr. Silverstein, do you have enough to go on here? If we continue this, if you move to continue, to allow you to get time to have a site plan review?
I don't mind, if he needs a straw poll, I don't mind a straw
Yeah,
poll.
I don't-
And can I just say one thing, Mr. Chairman? There's no problem with the straw poll, but you want to make it clear that it's in altering the use to allow storage, that it's the current building and the current storage facilities. Not that you just change the whole place and then you can have 40
Correct.
storage containers. You want to be very
Absolutely.
specific about, you want to be very specific about what you're doing.
Yes.
And I would certainly agree with that.
And that would be the conditions in the,
Yeah, in the special permit, once you got to it.
Right.
Yeah, exactly.
Okay, on that understanding, since I joined the board, there was a sort of a bad smell, there was to a straw vote, people thought it was, but I'm happy to entertain a straw vote, if everybody else on the board is happy to do it. It'll be a first since I've been on the board. We always would end here after hearing everybody's views, and the petitioner had to sort of guess and get his own sense of comfort in what had been said. But if there's a sentiment to allow a straw vote.
Well, Mr. Chairman, you don't have to take a straw vote. I think, if that's your custom, and since you've been on the board,
Yeah.
and you're uncomfortable with that, I get it.
That's fine.
It seems to me that each member could say what they're comfortable with, and I think they have. So I hope that's enough direction for the applicant.
I haven't spoken, I'm comfortable with the suggested course of action, special permit.
I guess it's a little unclear to me, because I've heard one no vote, or one indication of a negative inclination, 3 relatively open, positive views, and 1 member suggesting that she doesn't see a path to a special permit, but would to a variance, and that's a little unclear to me, because I think, as Mr. Ford said, that the standard for a variance is extremely difficult, and I think that the case for a special permit to alter non-conforming use is pretty clear. So I guess I'm just a little, right now, I'm not clear that there are 4 members positively inclined towards a special permit, unless I misconstrued that.
Well, I have to say, if you don't go forward with the site review, you can't get the special permit, so I don't think you have any choice. Or you'd have to try for a variance, which you just said is harder. So,
Well, I think at this point, it's been a long session, it's been a long process through this. He's made his case, we can continue on and have a vote. We could do contingent upon, I suppose we could, Mr. Ford, have a vote.
And he can always, and he always has the opportunity to come back and perhaps get a unanimous vote if he's convincing.
I mean, that's all fair. I guess I'll just say this, that Mr. Ford and I have gotten along very well. We've been very cooperative through this process. The idea behind a remand is to avoid litigation and try to determine if there's a path forward. And, I think this isn't, procedurally, we're not in the same posture as every other application that comes before you. And all I'm looking for, and we have to report back to the court, I'm just trying to get a sense of whether or not we're wasting time and money going through site plan approval only to get a denial of a special permit, which just puts us back in, the adversarial litigation posture where, I don't want to be, and I don't think the town wants to be. So that's why I'm just trying to get a little bit better sense. I mean,
I agree, Mr. Silverson. I think you're entitled to have a better, clearer view of where we stand here to make this decision. I agree with you.
Maybe the board members could all say where they are again. Maybe I didn't count correctly, so
I'd be supportive.
I would be supportive.
I would too. Austin made a very convincing argument.
I'm not supportive at this point. I would like to get more, information from the council as to how this is being altered rather than, totally change of use to me. But as it stands, you have 4 votes. Positive.
Yeah, you have 4 votes there, and I think, Sibel, we might be able to satisfy your concerns with conditions in our special permit.
Maybe there's, and I don't know, again, I don't know how often, not in my tenure on the board as far as I'm aware, issuing a special permit for a use in this way. I doubt it's the first time it's happened in the town. So maybe if there are examples of where we've done this in the past, that could help potentially. I do think it would be good, in addition to our leanings, I think we should lay out explicitly for the applicant what our conditions would be. I know we briefly mentioned the number of containers and so forth, but I think just out of fairness for him, we should just lay that all out explicitly along with our thoughts.
I have a quick story. I'll try not to take too long. My father-in-law passed away several years ago, and I had to take care of his estate. He had a building in the town that was non-conforming. I found a buyer. He went in front of the Zoning Board of Appeals to continue that non-conforming, and they came back to him and said, we want proof of what that non-conforming usage was from the person you're buying the property from. And I had to write a letter that was notarized and given to the Zoning Board of Appeals to show evidence that that building had actually continued in that non-conforming up until the time of my father-in-law's death. There are a lot of statements in here about things being a certain way and certain usage, but I don't see any evidence. And there's a lot of maybe some assumptions being made by the applicant. I don't want to, I'm not trying to disparage him, but he'd have a way to try and make things better than maybe they were. Is there any way to get any evidence that the trailer, there were really storage containers being rented previously on the property? Now, I'll give you the Cape Cod 5. It sounds pretty serious that they did that. You had the vault and all those statements, so I'll think that that's good enough proof. But I'd like some evidence considering just how, I don't know, significant this whole thing is.
Well, Martin, I think the testimony so far is that isn't what he's basing the application on. that it was previously used as storage. He said he particularly didn't want to go into that because it would have to go get depositions and get discovery to find the history of the place. The legal theory before us is that it's a pre-existing lawful nonconformance, and our statute, our bylaw, allows him to change the use of that existing lawful noncompliance. So he really doesn't need to show us there was storage there. I asked that question, maybe I
Right.
made
All right.
a version that shouldn't have, because it added extra appeal, I think, to me, that there's a column of storage there in the past. That isn't part of his case.
I mean, I do think I can make that case, but I don't think I need to, because I don't think anyone would question that this building, this property has been used for office purposes since it was built. I mean, I don't think I need to go back and,
No, I'm
don't
talking
say
about
things.
renting of storage containers on the property. That those were actually being rented,
Well, I don't think they were.
so.
I don't-
I don't think that's the nonconformity. If I
Right.
may, Mr.
It's
Chairman,
not
what he's
moving.
arguing is that the office building is nonconforming because it doesn't have a special permit. It was built before the requirement
I
of a
get
special
that.
permit for over 2,500 square feet. And he's seeking to change the use, alter the use, which includes changing the use to a storage property, storage in the building and the storage containers. So during this period of time, we could get the exact date that that footnote was inserted in the bylaw and make sure that the building was built prior to that. That's one of the things that could get done. So you're right, we could shore up the record, or the applicant could shore up the record, so you had something on which you could make a finding the next time he came back.
That would be helpful.
I would appreciate that if possible.
Yeah, no, I get it, and it makes a lot of sense.
and then I think the other piece of it is, I have to assume that a building permit was issued for this building when it was built.
Oh, I have no doubt. It
Yeah.
was Will Joy, Coastal Engineering. I'm
Right.
sure he went through, I have no doubt that
But
he
we
went
don't-
through
We don't have a copy of that building permit,
but I would be,
Mr. Walters and his staff searched, provided everything in the building department file, and it really only goes back to 2000. But we have to assume that the building permit specified it was issued for an office use. And so if somehow a building permit was issued for an office building, even if at the time a special permit would have been required, which seems very unlikely.
well, it was an office. I had a room on the first floor myself when it first went into existence. So I can attest
Right.
that it was an office when it opened up. For that matter,
Right, so I think whether or not, it would seem unlikely to me that everyone allowed this building to be built without a special permit being issued if a special permit was required. But even if somehow it were missed and this were built and used in accordance with a building permit 40-some years ago, it's still a pre-existing non-conforming use that can be altered by special permit.
But
And
all they're asking you to do is to put that in the record between now and the time you come back.
so understood, and,
Okay.
obviously, I did search, to see if I could find copies of old bylaws, old permits. But I think one way or another, it's a pre-existing non-conforming use. The other thing is, I did note that among the files that were provided were a number of subdivision approvals in and around the mid-'80s, early and mid-'80s. So that could have been done also for the purpose of zoning freezes. It's so hard to know, and through no fault of anyone here now, the records are just sparse, and it's difficult to pin it all down, and I'm not sure that it's necessary to get to the conclusion of this being an.
Well, anything you can find will be helpful. I think
Of
that's
course,
what we're saying.
I understand, and, you know, Mike, maybe you and I can figure out the best way to do that research.
The other thing, and I don't want to throw a wrench into all of this, but if your petition is that all of the building be changed to storage, you may have to consider the requirements of the Cape Cod Commission, because any change of use of an existing building over 10,000 square feet is supposed to be reviewed by the Cape Cod Commission as a development of regional impact. And so you may not have thought that through. It just dawned on me now when I was hearing the building's over 12,000 square feet.
I'm
So
sure we
that will be an
could
issue.
continue to use at least 1,500 square feet as office space.
Well, you may have to, is all I'm saying, and you may come back to this board and say, my request to change the use is for X amount of the building and the containers, but.
And that should probably be part of your presentation to site plan review. I think that should be thought out prior to going to site plan review.
Yeah, I just don't want you to get to site plan and then have site plan review say to you, wow, this is a change of use over 10,000 square feet, we've got to refer you to the Cape Cod Commission. So, just look at that issue, okay?
If I may add to that really briefly, it's not in the purview of site plan review. My role in that committee is zoning, but it is also a consideration of the building code itself, that, number one, the way to actuate a change of use for an existing structure is via a building permit application. And also, change of use from office to storage is a considerably higher pounds per square foot rating. And I don't know that the building, not having seen the designs for it or anything, I don't know what it's designed to sustain. So I just in fairness to the applicant, I want to make that clear.
Fair enough. I do think we have some of the old building plans that could shed light on that, and, you know, I know that it's solid concrete construction. There's no wood in there, so I'm confident we could get past that, but obviously any zoning approval doesn't exempt us from any applicable code requirements,
Right.
but we don't want to, you know,
Yeah, it's just
The zoning,
something to
obviously,
consider. It would be the matter for a licensed engineer to determine.
Okay. I think we're at the point, Mr. Silverstein, if you want to request a continuance to allow you to appear before the site plan, you should make that request, and we can take that as a motion to continue this hearing, date certain, the dates that, I don't know how long it will take you to coordinate with the site plan review committee. We have this, what's the ultimate date, we have to go back to the court?
Let me just look at that again, the last reading in order. I'm pretty sure it was June 12th. I read it when we got started.
Yeah,
June 14th.
June 14th, yeah. Yeah.
We have to have concluded and filed our decision, the board does, by June 14th. When do you meet in the month of May?
The 7th and the 21st.
You think you get back here by the 7th, Jonathan?
I cannot be here May 7th. I will be out of country. Just-
the 21st would work. I don't know generally how long it takes to get through site plan review. Obviously, we'll have to look at the submittal requirements and pull things together. We'll certainly do that as quickly as we can. But my suggestion, my request would be we continue to the 21st. If site plan review is still ongoing at that point, then we can jointly request I think that the court would be happy to know that progress is being made and to give the board more time for its decision, and we could agree to continue to another date after the 21st if we needed that time.
I agree with that. So that sounded like a request for a continuance to your May 21st meeting.
I'll make that motion. Is there a second?
I'll second.
All right. All in favor?
Yes.
Any
Aye.
opposed?
Aye.
Any opposed? You know what, we're on Zoom, I guess we have to
Yeah, you
call the
gotta-
roll.
Yeah, you gotta call the roll.
Sibel,
Yes.
Austin,
Yes.
David,
Yes.
Martin,
Yes.
and I'm also a yes. So that's 5 for the motion. Well, we'll see you in.
Well, do we also need to talk about the variance, correct? We have to vote to continue or withdraw that, correct?
For what it's worth, my view is that the hearing on the application, it's one application with multiple forms of relief requested alternatively. So from my standpoint, I don't think you need to take another vote. I think, I viewed it as continuing the entire application, the hearing on the application as a whole, but I'll
I'm comfortable.
defer to
That's
you
fine.
and your counsel.
Yeah, that's fine with me. Just wasn't sure if we had any obligation to talk about them independently.
We've been talking about them as a package, but it's a great question. And so let me just ask Mr. Silverstein on the record, to the extent we need it, because you have to handle a variance within 100 days. I don't want to get in a constructive grant situation. If you could represent for the record that you'll give us whatever extension we need to protect against any grant of a constructive grant on the variance application.
Yeah, certainly, because I think
Okay.
the 100 days won't even be close to running by the time we come back anyway, but absolutely, I'm not looking to pull any fast ones.
Okay, so I'll speak to Jen if she needs to send something out on that. Jerry, we can do that, get Jonathan to sign it.
Very good, thank you, Mike. All right, anything else to come before this hearing? Hearing nothing, do I have a motion to adjourn?
So moved.
Second?
There's a second, all in favor? Any opposed?
Aye.
Aye.
Thank you all very much, a long hearing.
Thank you for your time.